My name is Sunita Advani, and I'm the founder and chair of VYAP and an arbitral assistant to Mr. Michael Lee, an experienced English arbitrator member at 20 Essex. Before we begin, I would like to introduce VYAP's newly appointed editorial and publishing director, Bernice Tan. Bernice is a senior associate at Drew & Napier, specializing in commercial dispute resolution. And I'd now like to introduce our exceptional panelists. Our first panelist is Professor Jean-Marc Thouvenin, who is a professor of international law at the Université Paris-Nanterre, a member of the ICA panel of experts which developed the Paris Agreement's draft Conciliation Annex, the Secretary General of the Hague Academy of International Law, and a partner at Cigna Partners. Our second panelist is Charis Tan, who is a partner at Peter & Kim's Singapore office, where her practice straddles international commercial and investment treaty arbitration and public international law. Charis is appointed both as counsel and arbitrator, and she has also served as a panelist in WTO trade proceedings. Our third panelist is Dr. Túlio di Giacomo Toledo, who is a senior legal counsel and the current representative of the Permanent Court of Arbitration, or PCA, in the Republic of Singapore, heading the PCA's office in the country since 2020. He acts as registrar and tribunal secretary in international arbitrations and assists the PCA Secretary General with appointing authority matters. Our fourth panelist is Bart Wasiak, who is a senior associate at Arnold & Porter's London office, where he represents sovereign states and private sector clients in complex, high-stakes international arbitrations and has a particular expertise in investment treaty arbitration. My fellow co-moderator is Eva Tay Tsinghui, who is an associate at K&L Gates Straits Law LLC in Singapore, where she has an active litigation and arbitration practice across various industries and sectors like aviation, construction, commodities, shipping, and technology. There will be an audience Q&A round after the panel discussion. If you have any questions for the panelists, you may submit them via Slido. And for those attending in person in particular, you may alternatively raise your hands to ask your questions verbally. And with that, I'll hand it over to Eva to start with our first question of the panel discussion.
Yes, perhaps before we start, could we just check that Professor Thouvenin can hear us?
Yes, I can hear you very well, and I see you also very well.
Thank you so much. Well, our first question actually goes out to you. The first question is, what is the Paris Agreement and what is its role within the wider international framework for tackling climate change? How does the Conciliation Annex fit into this context?
Thank you for this question. But first of all, let me thank you very much, thank the organizers to have invited me to this panel. Obviously, I would prefer to be with you in Singapore. I'm here in an airport waiting for a flight to Senegal, which is nice as well. But honestly, I would have preferred to be with you in Singapore. So thank you for that. So the Paris Agreement, as you, I think you all know, has been concluded in my country, my city, in Paris, in 2015, within the broader framework of the UNFCCC. So the UNFCCC is a framework agreement, but the Paris Agreement is far more demanding, far more ambitious. It fixes a limit to the increase in the global average temperature to well below 2 degrees centigrade above the pre-industrial levels, and commits states to make their best efforts to limit the temperature increase to 1.5 degrees above a pre-industrial level. The agreement also commits states to regularly provide ambitious objectives of reduction of their own emission of greenhouse gases in the form of what we call the national domestic contributions, NDCs. It's a key element of the system. And the cumulative effect of the NDC should be to reduce the rise of the temperature. So now, if a state does not provide an ambitious NDC or does not implement an NDC, or if other elements of the Paris Agreement are not respected, what happens? So of course you have the name and shame mechanism that can be at play, and it is at play. If you look on the internet, the landscape, you will see a lot of scrutiny of what states do, what they propose in terms of NDC, and also the COP are following what is proposed. And you have sometimes indeed shaming effects, but it doesn't work well. And so there is also a dispute settlement mechanism. So the dispute settlement mechanism has been fixed by Article 14 of the UNFCCC, which is applicable also to the Paris Agreement. Elaborates a dispute settlement mechanism beginning by negotiation. If negotiation fails and if there is no agreement to go to arbitration or adjudication, then one of the parties to the dispute can request that a conciliation procedure begins. So you can see that here, and this is an important point, perhaps a crucial point, the conciliation mechanism is compulsory in this case. But that doesn't mean that it will end up with a compulsory, a binding decision. It will end up with a recommendatory award, but the procedure as such is compulsory in this case. The issue is that the UNFCCC and the Paris Agreement did not provide for the procedure to carry out the conciliation mechanism. So you don't have a procedure. You just know that there should be a commission, that it should be composed of equal number of conciliators plus one empire, if I can say so, but you don't have anything else. And then the UNFCCC says that the COP, so the Conference of State Parties, will have to adopt an annex precising the procedure. The problem is that it never happened until now. So the next step will be for the next COP, hopefully, to adopt the famous annex on conciliation.
Is also for Professor Thouvenin, and it is, what is the purpose and key features of the Paris Agreement's draft conciliation annex?
So for the moment, there is no draft, as you know. Well, or perhaps there are state drafts, but I don't know them. What I know is the proposal of the ICA, right, the International Council for Commercial Arbitration, which I did participate. So the purpose is to provide a procedure to ensure that the conciliation procedure will be carried out from the beginning to the end, and every step will be regulated so that to avoid any derailment of the procedure. So that's the objective. Of course, it's a classical thing because you all know that there are quite a lot of conciliation rules on the market, if I can say. The PCA rules, you have UNCLOS rules, you have many rules. So this is a classical thing, but you need one concerning the UNFCCC and the Paris Agreement, because if you don't have a rule, then you will need for each step an agreement by the parties. And if the parties then agree, you don't know what to do. So the purpose is that. So you will find in the annex the classical features you will find you need to clarify in a procedure for conciliation. How the conciliators are selected, chosen, challenged perhaps. This is quite close to what happens in arbitration procedures. You have also the notion that procedure will be written, exchange of memorial and things like that. And also there can be hearings if the commission considers it necessary and the parties agree. No, the parties don't have to agree, but they will be consulted. So that the commission decides if it needs hearings. There is a bifurcation possibility. So you all know what is bifurcation. When there is a dispute on the competence of the commission, but the bifurcation is not automatic. It should be decided by the commission if it considers necessary to deal with the question independently from the merits. And also you have other rules. It's quite long, and it's very much explained in context. So perhaps one important thing to have in mind in this proposal is that there can be a third party's involvement. So if there is a dispute between two states, you can have a third party involvement, which is, I think, a good thing, because climate change is not a concern for two states only. And so the Commission can decide to request or to receive information from third parties. It doesn't mean intervention, but it's information from third parties. A bit like, it's not called like that, but a bit like a amicus curiae, amicus commissionae, if I may say. And you have also, of course, the notion that at the end of the process, there should be, and the Commission will adopt at a majority, a recommendatory, that's a term, recommendatory award, which is not compulsory, which is not binding, but which the parties must consider in good faith. So that's the purpose of the work of the ICA, but of course it's a draft which is proposed to states and to help them to agree on a text to adopt at the next COP.
That's very interesting indeed. Thank you.
So now our next question is actually for both Bart and Túlio. What is conciliation and what are its advantages over other forms of dispute resolution in relation to climate change related disputes under the Paris Agreement? Perhaps Bart first?
Sure, thank you. I'm happy to be here. So I think Professor Thouvenin has already partly addressed the question of what conciliation is, but it might be helpful to kind of take a step back and just make sure that we're all on the same page and kind of know, the differences between the different forms of dispute resolution. And I think those lines between the different ways to settle disputes can be somewhat blurry, but I'll try to define some of the things that I think characterize conciliation specifically. And again, some of them have already been mentioned. So conciliation, I think, can be defined as a process whereby parties to a dispute request a third party, a conciliator or conciliators or conciliation commission, to assist them in reaching an amicable settlement of the dispute. So the idea is that there is a party whose job is to assist the disputing parties to find a way to resolve the dispute. Now, as Professor Thouvenin mentioned, the conciliator does not have the authority to impose any decision on the parties. So unlike, for example, arbitration, this is not going to lead to a binding decision. But what the conciliator can do is undertake an objective examination of the facts and various aspects of the dispute, including, and again, that's I think was mentioned, by hearing from any witnesses or experts. So there's this authority to actually investigate the dispute in some detail. And then the other role is for the conciliator to provide an appraisal, again, an objective appraisal of the parties' respective positions, and then to help them define or to come up essentially with a solution that hopefully will be acceptable to both parties. I found a definition in a publication called A UN Handbook on the Peaceful Settlement of Disputes Between States, and that defines conciliation, again, as comprising of two functions. One, to investigate and clarify the facts in dispute, and two, to endeavor to bring together the parties to the dispute in order to reach an agreement by suggesting mutually acceptable solutions to the problem. And I think what is also worth noting is that the conciliator need not necessarily just focus on legal issues, and instead may, as I mentioned, consider other aspects of the dispute, environmental, economic, any other aspects of the dispute. So it's not necessarily just a purely legal process. And indeed, it's been said that in the context of interstate disputes, conciliation can be said to resemble more a diplomatic process than necessarily a legal, certainly a judicial process. Again, it's about bringing the state parties together and finding hopefully an acceptable solution. In the interest of time, I won't touch on other alternative forms of dispute resolution. I'll just mention that mediation is obviously a similar process, but perhaps less even less formal, and doesn't necessarily involve the same level of investigating. It doesn't involve the mediator engaging the same level of investigation and kind of assessment of the facts. And then just briefly going back to your question about the advantages of conciliation, I think these will be obvious from what I've said, but one is that it is about bringing the parties together and achieving an amicable settlement, which in the context of climate change related disputes, I think is important because you're avoiding, hopefully you avoid a situation where one state, is going to be considered a winner, the other state a loser. It's, again, hopefully more acceptable to both states. Also, there's this room for the Conciliation Commission to examine the facts in some detail, including by hearing from experts. These disputes can be very complex. And so we can easily imagine that the Conciliation Commission would need to spend potentially weeks, months, hearing from experts, reviewing documents to fully understand all aspects of the dispute, which is something that conciliation allows them to do. And then finally, because it's such a flexible process, it hopefully allows for various cultural, historical, other issues to be considered and appropriately accommodated. Again, in climate change context, it's easy to imagine that the dispute may involve, a developing state from a, perhaps part of the world that's particularly affected by climate change, disputing against a developed state that, has a very, very different perspective, and there may be, various cultural issues there. And again, conciliation is a process that allows for all those different issues to be appropriately accommodated.
Thank you so much. I have to confess that I didn't know anything about conciliation before coming, today, and hearing the explanation really helps a lot. We'll now hear from Túlio.
First of all, thank you very much for the initiative and for having me here. It is a pleasure. And also thanks to KNL Gates for hosting us today. I agree with everything with what Bart just said. But I'll focus here on some of the procedural advantages of conciliation and why it might be suitable for helping settling this kind of disputes. And if you think about climate change related disputes, I think the first that comes to mind is the amount of people that are affected by these disputes. Like sometimes it's difficult to frame these disputes between two states. It is expected that such disputes may involve different states. So you easily reach a situation where you have a multi-party proceedings. But even when talking about multi-party proceedings, there are also many stakeholders. So climate change affects everyone, affects people, companies, NGOs equally to some extent. So one, thinking about multi-party proceedings, having a flexible proceeding that allows multiple parties to make submissions or just be heard, right? And finding a common acceptable ground to settle the dispute. But also allowing or giving an opportunity for these different stakeholders to be heard. And I think that's another key feature that why conciliation in this context might be more interesting than perhaps arbitration. Yes, you can have you can allow other stakeholders, third parties to make submissions in arbitration, but we all know that the process is a bit more complicated. It's more adversarial and depends a lot on what the disputing parties want for the case. Whereas in conciliation, perhaps there will be more flexibility for the commission to hear from these stakeholders. And drawing from the experience of the Timor-Leste Australia conciliation, it was important, especially in the third phase of that conciliation, as some of you may know, this was a conciliation proceedings that was commenced by Timor-Leste against Australia concerning the maritime delimitation in the Timor Sea. And the third phase of that conciliation concerned the exploration of some natural resources in the Timor Sea between both countries. And as part of the process to settle the dispute and help the parties come up with a solution for their dispute, the Commission engaged in several consultations with different stakeholders that included not only NGOs, the local population directly, but also those companies that were involved. So I think that this example also illustrates how conciliation can be an interesting mechanism for this type of disputes.
Thank you so much. I have to read up more about this conciliation.
So our next question is, what are some examples of climate change related disputes that you have come across, including under the Energy Charter Treaty and the Paris Agreement? So Professor Thouvenin, I'm grateful if you could share your thoughts with us.
Thank you very much for this very good question. Just before, perhaps I might say one further word on the preceding discussion, which is that, as you can imagine, the conciliation in this particular case of a dispute between two states regarding climate change cannot be settled taking into account the interests of both parties and perhaps the surrounding people only. I mean, it's a question that regards, when it comes to interpretation of the Paris Agreement and the UNFCCC, that interests the whole world. And so I think there is less flexibility than what you can find when it comes to conciliation and the law of the sea, when it comes to the delimitation of a maritime boundary. Here we talk about a common feature of the humanity, not of a sharing of a cake between two states. And this is why the ICA has proposed in its draft that the conciliation should rely on the text of the UNFCCC and or the Paris agreements and take account their objectives. So taking account the objectives is important, of course. But of course, you have also in the UNFCCC and the Paris agreement a lot of flexibility. So in the text itself, you have flexibility, but you must keep on this objective to limit the climate change, the warming of the climate. So to come back to the question of what I crossed in my practice. So I was involved in the unclosed advisory opinion, but I will let that for Charis, I think. And I've been involved in the advisory opinion before the ICJ. And here if you listen to and you read the pleadings of the parties of the different states intervening to explain to the court what it should say, then you will see disputes between parties regarding interpretation of the Paris Agreement mainly. So, for example, the big dispute before the court, and it was also the case before the ICLOS, is whether the climate regime, which is the UNFCCC, the Kyoto Protocol, and the Paris Agreement, is it lex specialis, excluding the application of the lex generalis, which is the other feature belonging to international law. So, for example, can you say that the Paris Agreement and the UNFCCC excludes the application of climate change questions of the UNCLOS? And that's one of the big debates, and some states supported this view. Also, must you consider that the Paris Agreement, in putting together kind of a liability system, the loss and damages question that is dealt with by the COP, that is mentioned in the Paris Agreement, is it lex specialis in that it excludes the implementation of the law of state responsibility, which is an important feature of general international. In other words, if a state does not respect its obligation under the Paris Agreement, is the state responsible under the classical rule of state responsibility for wrongful act, or do you simply apply the Paris Agreement? So this is a big dispute before the ICJ, and we'll see what the ICJ respond. And there is also a question whether the NDCs, national domestic contribution, so what every state pledged to put in motion to reduce its emission of greenhouse gases, are these NDCs creating an obligation? Or is it just, I say what should be my politic, I will be my best effort, but if I can't, I can't. So there is a dispute also on the bindingness of different features of the Paris Agreement, including the NDCs. So I urge all of you to take a look at what the ICJ will say on these different debates, because it will clarify a lot of the disputes regarding interpretation of the Paris Agreement nowadays.
Thank you, Professor Thouvenin. Charis, you could share your thoughts as well.
Well, I have such a loud voice. Clearly, I don't need a microphone. Good evening, everybody. I have some old friends who are laughing right now because they know I'm always like that, even when I'm at lunch with them. So, what kind of climate change disputes have I come across, right? I'm going to go through maybe 4 types. The first is, of course, the state to state. And Jean-Marc said something about ITLAW's advisory opinion, of course, the ICJ. And I'm going to go a little bit more into the ITLAW's advisory opinion later. Sorry if my voice is weird. Just tell me. The second is, of course, ISDS cases. And that's what I think, Bart, you're going to pick up. The third is climate change related domestic litigation. So these are happening in courts all around the world, right? A lot of times NGOs or individuals, they are bringing cases relating to, for example, breach of legislation or breach of the constitutional rights to life, to health because of climate change. That's how they are hinging a lot of these cases. The fourth, and I'll call this sector specific or business to business type of disputes, right? So one sector specific one is, for example, oil and gas, the oil and gas sector. So one of the things I do is also upstream oil and gas, where you have oil blocks that are contracted to international oil companies, right? And basically after exploration and development and production, these oil blocks at the end of their term, maybe 20 years, 30 years or 50 years, they have to be returned to the government. At that point, there is usually in what we call the production sharing agreement, the contract between the government and the international oil company, like a Shell or an ExxonMobil, right? That contract, there will be a clause called the reinstatement clause, right? That's the clause that operates where you're supposed to return, so Shell is supposed to return the oil block to the government. And what is the state of the oil block, the environment in the oil block that you're supposed to return to the government, right? Because you would have, during exploration, production, you have drilled all these oil rigs, etc., right? So this is coming out as a very big issue in many disputes. Why? Because many of these, what we call production sharing agreements, were signed 20 years ago, 30 years ago, 50 years ago, and a lot of them, their reinstatement clauses are very bare bones, very simple. But of course, nowadays, you look at what the world is saying, right? The environment's different. You need an EIA, the environmental impact assessment. You need to reinstate in this way. And suddenly the government wants to impose from a one-liner to a 50-page obligation, right? Of course, I'm exaggerating a little bit. But there are all these sorts of tensions and unhappiness that's leading to dispute. I wouldn't say too much more, but climate change related disputes in business is extensive, right? You imagine, I have friends who own investment companies, or rather they are partners in investment companies relating to investments and funds that are set up for sustainability or for certain purposes, right? And then what happens if your investor says, hey, wait a minute, you're supposed to be investing in this way, right? Contractually, you're supposed to be investing in an area, but then actually you are going against your climate change related obligation. Banks themselves are looking at a lot of greenwashing. What are these sorts of issues? Are they going to be sued? Are they exposed to liability? That's a lot of discussion amongst banks. Okay, so I won't belabor it too much, but in short, you think about any kind of dispute, you could potentially have a climate change angle to it. Now, the ITLAW's advisory opinion. I am very afraid, Jean-Marc, to speak in front of you because you know it inside, outside. I did try to study it at 3 a.m. last night, but I think you can still correct me, Jean-Marc. All right. So I'll give you a bit of outline, right? It's much more interesting if you read it yourself. Actually, it's quite a well-written one, but when you read it properly, you see how the tribunal was trying to push boundaries a little bit, figure out what the law has said can be interpreted to say, right? And I'm just going to be quite careful as well as to how I phrase it, because different people will have an extensive range of takes on the advisory opinion. Okay, so first, somebody tell me who brought the request for the advisory opinion before it lost. COSIS. And this is important because later we're going to pick it up on another question. And so think about it, right? Who is COSIS and how did they manage to find jurisdiction for the tribunal? Okay, so COSIS, C-O-S-I-S, and I can give you the full name. It's the Commission on Small Island States. Okay, so we'll talk about jurisdiction later. But in short, it discussed many different unclosed provisions, right? The United Nations Law of the Sea Convention. Sorry, it's a mouthful. Unclosed provisions. But what they honed in on in particular is Article 194, right? And I realize I should have put this up on the screen, but I will read to you Article 194 from my trusty old falling apart Bible. Article 194 of UNCLOS, paragraph 1, states shall take individually or jointly as appropriate all measures consistent with this convention, necessary to prevent, reduce, and control pollution of the marine environment. Okay, and that's one key obligation, because the tribunal then discussed, okay, what do we mean by all necessary measures, or measures that are necessary? And they said, look, you need to interpret this obligation objectively, and you need to look at two aspects in particular. Number one, the science is important. Number two, what are the relevant instruments? And when they say what are the relevant instruments, they say the two very important instruments, among others, are UNFCCC and the Paris Agreement. So they then go into, okay, interpretation, but application. What is the role to be accorded to the Paris Agreement and the UNFCCC? And Jean-Marc already picked this up. He talked about the big debate. You know, is it lex specialis? Does it supersede, etc.? So I wouldn't go into that. But what the tribunal, I can tell you what the tribunal said. The tribunal said, yes, you need to take into account all these other specialized treaties, but importantly, they do not supersede, they do not modify the obligations under UNCLOS, right? So they are stand-alone obligations. And they then used the UNFCCC and the Paris Agreement to sort of read in what are the relevant standard, what's the relevant standard when you talk about necessary measures, right? By saying that, look, the Paris Agreement and the UNFCCC give you relevant international rules and standards. So let's take reference from them, so to speak. So that kind of comes in. And they then talked about, okay, the next point I wanted to bring up. The principle of common, same but different. I call it the same but different. Okay, the more elegant way of saying it is principle of common but differentiated responsibilities and respective capabilities. But let's call it the same but different principle, right? And they say, look, this is a principle from under which is enshrined, and you find it both in the UNFCCC and also the Paris Agreement. And actually, when you look at how the UNCLOS provisions the obligations should be implemented, you should similarly take this idea that it is different between different states, right? Same but different. And how one very interesting observation, which I have to say, when I read it, I certainly agreed with it. It struck me that even the first time I read the decision, right? Is it, look, if you think about the UNFCCC and the Paris Agreement, it's very ground up. That's the nature of climate change. It's very ground up, right? It's, okay, states, nobody can impose on me, but how am I going to commit to NDCs, etc., right? And then how am I going to implement? Everybody has the right to implement in the way that they consider best in their circumstances. So in that similar way, the UNCLOS obligation also needs to be implemented. Okay, I'm going on a bit long, so I'm just going to do the last one, which is Article 197, Principle of Cooperation. And this is very interesting because Jean-Marc also mentioned it, right? Is it just about an outcome? It isn't. That's what the tribunal is very clear. It isn't about an outcome. You cannot obligate states to figure out an outcome, but it's about effort. So you have to, it's an obligation of conduct. That's what those are the words they use, right? So you have to do it in good faith, and you have to demonstrate that you're trying to do it in good faith. Okay, I pause here. I'm sorry, I've gone on so long.
Thank you, Bart.
I'll focus on the part of your question concerning the Energy Charter Treaty. And probably everyone in the room knows this, but again, just to briefly orientate ourselves, this is obviously a multilateral treaty with about, I think, approximately 40 states, well, actually not just states, members, including the EU, although the number is changing, decreasing. But it deals with, broadly with cooperation in the area of energy. And one chapter of it deals with investments and the protection of investments. So it's, you know, from for our purposes today, it's essentially an example of an investment treaty, which grants investors, foreign investors, investing in one of the or another ECT state certain protections, and then also provides them with the right to initiate an arbitration if the investor considers that the state has breached those. Has breached its obligations. Now, there have been, I don't have the exact number, but there have been definitely at least 150 arbitrations under the ECT. I personally had the pleasure of working about 10 of them. So this is a treaty that certainly has been very popular and perhaps as a result, very controversial. And we don't have time today to go into detail, but you know, a lot of people consider the ECT to be an example of a treaty that allows fossil fuel industry to essentially slow down the process of you know, energy transition, or if not to slow it down, to at least, you know, receive very often you know, some people would say generous compensation for measures that states take, you know, with the aim of, you know, addressing climate change. So there's a lot of people out there who consider the ACT to be, you know, terrible for the climate, and that's one of the, or probably the main reason why many states have withdrawn or announced their withdrawal. Now, I will say, and I'm not expressing a personal opinion here, but I will say that there is perhaps an alternative view, which is that the ACT also protects investors in the renewable energy sector. As some of you have heard, there have been a whole bunch of cases, for example, brought against countries like Spain or the Czech Republic concerning investments in the solar electricity sector. And essentially what happened there is that both states, respondent states, host states, reformed their subsidy regimes and made them less generous, and then as a result faced a large number of ECT claims from investors who considered that, you know, their investments were harmed. So there is an argument to be made that by protecting investments, including renewable energy investments, the ECT provides investors with certain, you know, encourages those investments essentially. So there is that argument to be made. But in the interest of time, I'll just make one other point briefly, which is that the ECT so far has not been used, as far as I know, in a way that would be that, you know, many of us probably would think about in terms of, you know, a good way to kind of encourage states to do the right thing. So there have not been any cases, for example, brought by NGO type organizations seeking to use the treaty to again encourage states to comply with their environmental obligations. But I think that's not to say that such a case could not arise. I think with a bit of perhaps creative lawyering, that is possible. And I will just mention one precedent that seems relevant. There was a case called Allard against the government of Barbados, where the investor argued that the respondent state breached its obligations under the relevant treaty by failing to protect the environment. So the investor, I think, owned some kind of an eco-tourism business, and it argued that the government of Barbados had not protected the environment, and as a result, its business suffered. Now, ultimately, on the facts, the tribunal dismissed the case. And again, I don't have time to go into detail, but I think that illustrates that there is potentially scope for investment treaties to be used that way as well, and for either individuals or perhaps companies to argue that a state that has not done enough to protect the climate and to address climate change has indirectly adversely affected an investor. Again, most people consider the ECT and similar treaties to be kind of bad for from the climate change perspective, but I think there is also an argument to be made in the other direction.
Thank you, Bart. Túlio?
And well, just provide an overview on other areas that we might see climate change related disputes, and talking about international law as well. But I don't know to which extent you're familiar with WTO, international trade. There are international trade lawyers here, but also we are seeing similar developments in the field of international trade. Well, as you know, outside of the WTO system, countries, they engage in sign bilateral treaties, multilateral treaties, and so on, right, to improve market access and increase trade flows. The traditional sense of a bilateral trade agreement, you would imagine, is a country commits to reduce tariffs in certain products, whereas the other country decides to do the same. Therefore, you reach a win-win situation. But the whole purpose of the agreement was to reduce trade barriers. But then it became a second generation of trade agreements, whereas the parties also decided to reduce non-tariff barriers. But right now, the new generation of these trade agreements that we are seeing, they also attach some conditions to this, to increase of market access, for example, by making sure that the state is complying with, inter alia, climate change related obligations. So we might see as well, also in the field of trade law, opportunity for further litigation in that respect. So certainly, not only the ICJ advisory opinion might have an impact in that field, but if you're an international dispute settlement lawyer, that's another area that I would invite you to keep a look on.
Thank you, Túlio. Very insightful contributions from our panelists on this.
For our next question, perhaps we'll go to Charis. I just love your energy.
Yes, especially at 8 p.m. Not yet.
What are some of the key legal and procedural challenges that parties may face in climate change-related disputes?
So let me make one substantive point, then I'll make a softer point, and then I'll hand over to my left and my right to add on their wisdom. Now, the substantive point is this, right? One challenge is that you just look at the law. It is by its very nature evolving. We are trying to figure out the science, the law, how does it all fit together all at the same time, isn't it? Right? You look at even the law's advisory opinion, it's well written. It is well written. But they have to look laterally in order to figure out how are you interpreting, how are you applying, what does actually the decision itself says UNCLOS is a living document. That's what treaties are. You write them decades ago, and then they're supposed to be living. But if they're living, how do they evolve and how are you going to interpret them? So that's part of the challenge. The need to think laterally, to reason laterally, and what's more, it's to convince the hearts and the minds of the decision maker, right? So for instance, in the in-laws advisory opinion, it's not about whether or not climate change is real or whether or not we should protect the environment. It's not. It is about what is the legal obligation and how far does it stretch. So that's one legal substantive challenge. The softer point is this. I promise I will come back to jurisdiction, causes. Who's in causes? Which are the states in causes? Can people name some? Jean-Marc, you're not allowed to. Oh, well done. Vanuatu, yes. But yeah, hey, this one spoiler. This one the best student. That's right. Yes. But in short, there are many small island states that got together that many of us would not be familiar with. But why did they come together? They said, climate change is a big problem. Sea levels are rising. And when we are just one, our voice is very soft. We need to get together to make our voices louder, right? And that's how they found COSIS. And do you know when COSIS was set up? Anybody knows? I'll give you MCQ. 1990s, 2000s, 1980s. So 80s, 90s, or 2000s? Or none of the above? Yes! 2021, guys. 2021. And the COSIS agreement is then part of the basis for the jurisdiction of the in-laws advisory opinion. Does anyone think that maybe even when they signed that treaty, that agreement, the COSIS agreement, they were thinking we might need it to get an advisory opinion? If we want to figure out what the law is, how are we going to get this before a tribunal? I don't know. I don't know the real answer. You can ask Jean-Marc. Yes. So, right. So what is that softer point? The softer point is this. Climate change, because by its very nature, it's not just about civil society and multi-layers. Yes, it does involve so many multi-layers of civil society, B2B, you and I, the man on the street. But it's also about states, right? States have to laterally canvass each other. So it's not just about the law, it's about canvassing this diplomacy, politics as well. States have no friends, they have interests. And their interests sometimes will diverge. But how can you find common enough interests in order to push the agenda forward, right? Okay, sorry, before I go on too long, is the left or the right going first? Both are just as good looking, so.
I think I can touch quickly on how these disputes can become politicized, right? And I think, and now turning back to conciliation as an alternative, perhaps as a method to settle these disputes involving states and etc. And then that brings me as well to another procedural challenge that we may see in these disputes, which is also the question of transparency and confidentiality. It is true, climate-related disputes, they tend to be heavily politicized, especially nowadays. It affects everyone, so there is a legitimate interest from the population, from stakeholders to be involved in these proceedings and to know what is happening. But at the same time, the purpose of conciliation is precisely to have a frank conversation between the disputing parties and with the conciliators and so on. So how you draw this balance? Some people said or framed this issue as the double-edged sword of transparency. So in some extent, yes, you want lean towards full transparency, but would that be helpful to settle the dispute? Perhaps we need to be more careful in that respect. I'm not here advocating that we should have a full confidential proceedings, especially in relation to disputes. That's definitely not my case, but it's certainly a food for thought. And I think the draft prepared by the expert panel under the umbrella of ICA, I think they draw a good balance when it comes to making sure that transparency is in place, making sure that these proceedings are in place, they exist, who are the stakeholders, who are the commission, but also ensuring that where necessary, the commission can have a closed door conversation with the parties, stakeholders, and so on. And one important feature as well of conciliation that perhaps for judicial settlement or in the context of arbitration might raise some eyebrows is the fact that in conciliation, the conciliators may have ex parte meetings with the parties, often to hear from them, again, in a safe environment, what are their concerns, what are the points of possible concession, have a similar meeting with the opposite side, so then you can work towards having a common goal. But again, don't take for granted that full transparency is perhaps the best path. It's a much more complex issue, precisely in view of the nature of the dispute. It can work both ways.
Yes, I think Professor Thouvenin would like to share a bit as well.
Yeah, I think it was very, very important to say that. And for people to understand, the Paris Agreement contains rules that are concerning the whole world, but also arrangements that are supposed to guarantee or support transfer of funds, of support from the north to the south, right? So there is this notion of loss and damages and cooperation, transfer of scientific knowledge and support, basically. And so you have two things. You have, one is the common objective of reducing or not letting the global warming to go too far, which is really interesting the whole world. And you have more limited questions regarding whether such state has received sufficient support from such other state, etc. And I truly believe that when it comes to these disputes regarding this second part of this second category of obligations, yes, conciliation is very much on point, must not necessarily be transparent in terms of, because it could create incentive for more, a rush for obtaining concessions from one state, to accepted concessions to one state. So yes, I think it's important to clarify that. I wanted also perhaps to come back on the causes, because Charis sent me some bridges for that. So causes, so how was it created? I mean, the Commission of Small Island States, two very little states, peanuts in the ocean, who forced basically the whole world to discuss whether UNCLOS, the Law of the Sea Convention, has something to say regarding global warming, and more precisely, something to say regarding emission of greenhouse gases in atmosphere. So the connection is not that clear. But these two states succeeded not only to force the whole world to say what it thinks, but also to obtain from the ICLOS the confirmation of something which was said in some articles of doctrine, but many doubts were there on the table, confirmed that yes, UNCLOS has something to say regarding global warming. And that's incredible, in fact. If you look at the law of the sea, why would that have something to say about emission of greenhouse gases in the atmosphere in Paris, for example? But it has something to say about that. And the second very important point to very well understand is, why was it so important for process to try to obtain this answer? Why was it? What was the purpose? Of course, clarifying interpretation of UNCLOS, and of course, obtaining confirmation that it has something to say about the global warming. But also, you must know that the UNCLOS has teeth, as we say. There is a compulsory mechanism of settlement of disputes, ending up with an award or a judgment. And this is what I call teeth. If you have a dispute, you can, if you have jurisdiction, you can go to the court or to the arbitration or to ICLOS to obtain a judgment or an award. which is what I call TIF. If you look at the Paris Agreement and the UNFCCC, you don't have that. You might have, if the court adopts an annex, which was the subject I discussed first, you might have a conciliation mechanism, we discussed that, but you don't have really TIF. And this is why COSIS obtained, I think, a huge success. 2 peanuts in the ocean, I think, changed the world.
Thank you so much for sharing about that. So interesting. So thank you, Túlio, as well.
So our final question is one of especial interest to all our junior lawyer attendees, which is, what advice do you have for junior lawyers who wish to develop expertise in climate change related disputes, particularly under the Paris Agreement, and assist with conciliation in respect of the same? Professor Thouvenin, grateful for your thoughts.
So, well, I think that everybody would agree with me that the very first thing is to be a good international lawyer. You cannot be an expert on climate change, and that's only that. I mean, you cannot begin by that. Exactly like you cannot say, oh, I'm into arbitration, full stop. You must be a generalist first. Charis said a moment ago that when it comes to climate change disputes, you have many ways of trying to resolve the disputes or to make something from this dispute. You can use perhaps human rights and human rights courts. You can use perhaps, as you said, UNCLOS now and go to ICLOS or the RCJ. You can also try to rely on general international law, and you may know that there is a rule of general international law which says that a state is not allowed to let its territory used in such a manner as to damage another territory, the territory of another state, etc. So having a broad overview of the international legal system, I think, is the first key, is the first requirement. And for this, of course, you must study and also perhaps confirm what you studied in coming at the Hague Academy of International Law. So you know that in the Secretary General of this marvelous institution, it's in the Peace Palace, and honestly, it's a marvelous experience. It's a non-profit institution, but I truly think that every student loving international should try this experience. The second thing, of course, and Charis also said so, is to be capable and to like difficult questions, because you have to cope not only with legal questions, which are not so easy. You know, take a look at the UNFCCC and the Paris Agreement. It's not easy reading, but also you must be willing to understand the techniques behind the science. If you don't cope with the science, you will be quite far away from these questions and the problems. And also to follow the science, you can also follow what the COP say, and they speak a lot. So there is a lot to read. The third thing, indeed, is perhaps probably to be quite interested in procedures and the different avenues to resolve disputes or to challenge a state or perhaps a oil company when it comes to what it does regarding climate change. So knowing the landscape is quite important. The different avenues you can use. And coming back again to the ICLOS, it was at the time the only avenue available for these two states, these two, I said peanuts, but it's two little island states, to try to make something out of their despair. Well, these two states are, as Charis said, they are supporting the warming of the ocean and the rising of the sea, destroying their lands, and they fear also to lose their access to the sea through their baselines. And they were despaired, and they needed to do something. And they met lawyers, me and a friend. We were two lawyers, and we said, okay, perhaps we can think with you out loud. And the idea was to say, why not an advisory opinion? Okay, we need an international organization. How can we create an international organization? You need 2 states. Already, yes. If you're a lawyer, you know that. And you just have to draft the statute of the organization, take care of having a provision saying that the organization has a legal personality, because if not, it's not very serious. Try to have headquarters, staff, and you have it. And then you can go to the EPLOS. You just have to write down the question, which was a long work, even to arrive at 2 very little paragraphs. I can tell you it was a long work. And then you can make things of it. So yes, general international lawyer, loving difficult questions and capable of activating the different avenues available. And what I always say to my students is, when it comes to international law, use it. So I'm a rugby lover. You know what is the rugby? It's a play. It's not exactly like football, but it's better, I think. And the arbitrator in rugby game always say to, when the ball is not moving, use it. International is made for that.
We'll definitely keep that in mind. Thank you, Professor Thouvenin.
I think we probably would, all 4 of us would agree, or all 3 of us would agree, Professor Thouvenin, that to practice climate change-related disputes, one needs to be a generalist and one needs to build a solid understanding of international law. And it's probably difficult at this point to specialize, for anyone to specialize specifically in climate change-related disputes. I'm sure there are people who do that. Perhaps Professor Thouvenin is one example, but in general, this is still an emerging area, and so I think realistically, most of us will now and then come across climate change-related disputes, but not just those kinds of disputes. And I guess my point is that even if this is the area of law you really want to get into, I would say that, yes, you may consider perhaps ultimately working for a government, working for an NGO, but I think I would encourage people to just practice law, international law, including commercial disputes, and perhaps start by doing pro bono work. And depending on the firm you're at, you may have actually quite a lot of opportunities to advise clients, including potentially states, on climate change-related disputes. And that's, especially I think for a junior lawyer or an aspiring lawyer, maybe the easiest way to kind of get into this field and to gain some experience.
Very useful advice. Thank you, Bart.
Yes, perhaps Túlio as well. Yeah.
Let me just quickly say that as a Brazilian, I have to say that I protest the comparison between rugby and football. I highly disagree, Professor Thouvenin. Je suis désolé. Although we have a very sad history when it comes to confrontations between Brazil and France. So let's stop here. But when it comes to, so I had a conversation with a colleague who has been following these discussions much more closely than I, and he said that he feels there is a gap in the field for specialists that are able to talk with international dispute settlement lawyers and at the same time with, let's say, the substantive law lawyers in the field of climate change. And that really made me think about it, and perhaps that is an opportunity that perhaps junior lawyers may try to find a way in. If you think about it, we talked about the different venues that these disputes may arise, right? So in the context of national courts, but also international tribunals, commercial arbitration, investor-state arbitration. I mentioned trade law as well. It doesn't mean that if you are involved in these national court litigations that you are a domestic lawyer, period. Like I'm sure, and as you know, that in many of these disputes, international obligations, issues do arise and are mentioned and require the sort of expertise that Professor Thouvenin mentioned, that Bart mentioned as well. But think about how you can bridge this gap between a dispute settlement lawyer and these more expert lawyers or specialists in the field, and how you can contribute.
So the three of them have already said everything that is very practical. I'll say something from the heart. I think in life, there's a lot of failure that you face, but just turn up, just stay interested. That's reality. You will run into walls, but it's okay. Go home, cry, sleep, get up again tomorrow, right? Yeah, Winston Churchill said, success is never final, failure is never fatal, courage is what matters.
Thank you, Charis and Túlio.
Yeah, I think we've overrun our panel a little bit, but perhaps we have one question from the audience.
Thank you. My name is Fan. I'm a PhD student from NUS Law. So I have a question that goes to perhaps Dr. Túlio. So the panel just now have briefly discussed the role of conciliation in climate change dispute. And then I noticed that the PCA have two sets of rules regarding conciliation. So one is optional conciliation rules, and the other is optional rules for conciliation of disputes relating to natural resources and / or the environment. So I wonder if you could share, if you could explain the motives of dividing these two sets of rules. Is there any special consideration of, climate change disputes that you need separated rules for conciliation for environment disputes? Thank you.
Sure, thank you. Thank you for bringing this up. I think the main feature, the main feature of the procedural rules for environmental disputes is the fact there is a panel of specialist arbitrators and experts. I think that's the main point and the main feature that at the time the contracting parties, they thought that, well, there's an opportunity, there's an development in the field that at the time the discussions around this rule started in the 90s. So you see that these are not new issues, right? So, and the point is that there was already recognition, and we didn't mention this today, but we know that this kind of disputes demand some sort of special expertise. And the whole point of having this specialized set of procedural rules is precisely to set up these panels and have people that have expertise. These panelists are appointed by the contracting parties directly. And in case there are disputes under this set of procedural rules, parties can resort and appoint arbitrators, adjudicators, or experts that are deemed to have the necessary expertise. And by the way, we have also a set of procedural rules dedicated to outer space related disputes that follows the same idea. It's a very specialist, or it's a very niche kind of dispute. It might not be easy to find the experts.
Thank you so much to all our panelists and to our audience today. I think we've come to an end, unfortunately. Thank you so much.